Hello, everyone, and welcome to today's webcast. My name is Ben Frost, and I'm with APA's Northern New England chapter, and I'll be moderating today's installment for the Planning Webcast series. The series is brought to you by a consortium of over 30 of APA's chapters and divisions, and the consortium itself is not affiliated with APA. There is a loose-knit association whose mission is to provide comfort to planners that will help them meet their certification maintenance requirements. Today is Friday, April 19th, 2019, and we'll hear the presentation, New Federal Rules for Cell Towers Inside and Outside Rights-of-Way. For technical help during today's webcast, type your questions in the chat box found in the webcast toolbar to the right of your screen, or call the 1-800 number shown. For content-related questions related to the presentation, type those in the question box located on the webinar toolbar to the right of your screen. We'll answer those at the end of the presentation during Q&A. Here is the list of sponsoring chapters and divisions so far this year. I want to thank all of them for participating and making these webcasts possible at no additional charge to their members. If you don't see your chapter or division listed here, contact your executive committee and get them to become a member. Today's webcast is sponsored by the Northern New England chapter, consisting of Maine, New Hampshire, and Vermont. You can visit us at our new website, nneplanning.org. And here are a couple of upcoming webcasts. Stay tuned for more, and you can get all information on all webcasts at our website at ohioplanning.org/planningwebcast. To log your credits, log into your APA account at planning.org. You can search for CM activities, and you can search by the title of this presentation or by the event, which is number 91715558. All presentations will be found also on our website. You can like us on Facebook. It's the best way to find up-to-date information about the webcast series and upcoming events. We are recording today's webcast, and it will be available on our YouTube channel. Just search Planning Webcast on YouTube. A PDF of the PowerPoint will also be available on our website. And now I want to introduce our speaker for today, Gerard Lederer. Jerry's an attorney at the Washington, D.C. firm of Best & Krieger, where he advocates against preemption of local, public, and private property owners' rights in state and federal legislative bodies and before corresponding regulatory agencies. He is one of the nation's leading authorities on marketplace solutions for deployment of small cells and other wireless technologies, including municipal broadband and Wi-Fi services. We are indeed fortunate to have Jerry with us today, and I'm going to turn it over to him now. Jerry, take it away.
Thanks, Ben. Much appreciated. You can hear me okay?
We can hear you fine.
Terrific, terrific. All righty. Well, good afternoon, everyone. Let me get my page set up so that's full. Hi, this is Gerard Lederer. Actually, today I'm not coming to you from D.C., but I'm coming to you from the campus of Elon University. My daughter is down here doing an accepted students tour, and they were kind enough to set me up in a nice conference room. But because of that, I wanted to let you know that my colleague John Gasparini is also on the line. John is part of the Walking Wounded today. He's not feeling very well. He's at home, but we've got John online as a backup in case our connection is lost or if I make a major mistake. On the fly here, I want to also give him another job. John, in the chat box, if you wouldn't mind tracking the questions to see if something comes up that I miss as we're going along, we can try to answer quick ones along the way if somebody just needs something tweaked. Our agenda today is pretty simple. We're going to talk about the small cell orders. Again, that's not a typo. Small cell is not just the September 26th order, or what I call the CAR order for shorthand, but it's also and we'll go through it. I believe that there are three orders that are impacted. One is the NEPA, National Historic Preservation sort of Retreat Act. That was the first order. The second order is the moratorium. The third one being the CAR order. So we're going to talk about what those are and what the deadlines are. We're going to give you an update at the end of where the appeals stand. We being Best and Krieger represent the very large coalitions of local government and local government associations that have appealed the small cell order. Actually, we appealed the moratorium and the car order. And then we're also working with some colleagues that are representing other local governments that have also appealed it in a unified coalition. I'm going to throw one single slide up on where things stand in the states, because the most important question every single planner has to ask themselves when they are faced with any planning question when it comes to small cells in the rights of way or small cells outside of the rights of way, the first question you have to ask yourself is, has my state passed a law? Because your state law has not been preempted. And the bottom line is that whatever your state does, if it's more restrictive than the feds, then it's going to be enforced at the more restrictive level. If it's less restrictive than the federal rules, then it's going to be enforced at the federal level. So the bottom line is, whatever the most restrictive standard is towards local government, be it under federal law or state law, you're going to have to comply with the most restrictive. And then when we're done that, I just wanted to sort of give you two heads up of two other major threats that impact you. One is this idea that the FCC wants to allow cable companies to offset their in-kind, or that is their non-financial obligations under a cable franchise, that they get to offset that against the 5% franchise fee. And then a new proposal that's just come out that will make planners absolutely crazy, and that is the extension of the OTARD rules, the OTARD protections to network facilities and to backhaul. And again, we'll talk more about that when we get to it. The bottom line is, though, at 2 o'clock, whether I'm done or not, Ben has strict requirements to come in and cut me off so that we can get to the Q&A and we can move forward. So let's get started. The implication of the FCC small cell orders, they're the three that we talked about. First one is the departure from historic preservation and environmental sensitivity. The second one is the moratoria. The third one is the car order. It's the one that has most of the details with respect to small cells. So the first order, what I call the NEPA order, the holding there was deployment of small cells. That is a facility that's 28 cubic feet or less, not counting the antenna, is not a federal undertaking and therefore will not trigger the federal obligation to examine any historic or environmental impact. Let me translate that into English. The feds have left the building. The bottom line is, if a state or local government wants to protect a historic or an environmentally sensitive area, you're going to have to do it at the local level because the feds aren't doing it anymore. That order is currently on appeal. We're not part of that appeal, but in the meantime, understand that if your community had traditionally relied upon the National Historic Preservation Act or the National Environmental Protection Act to deal with small cell deployments, both inside and outside of the rights of way, that's no longer a good thing to do. You can no longer do that. If you want to act, you need to do it on your own. Again, it's basically the feds have moved out of historic preservation business for small cells. Here's a little bit more detail. I unfortunately don't have the time to stay there. We're going to keep moving. The other order was issued on August the 3rd, and that's the moratoria order. The moratoria order holds that express moratoria and de facto moratoria, that is it written in the law or is it in practice, they are generally prohibited. If they prohibit or effectively prohibit the provision of a telecom service, that is a violation of federal law, and it's not saved by any form of right-of-way management reservation. Okay. The problem is that they gave two terrible examples. They cited freeze laws up in the northern states. Now, what a freeze law has to do with the deployment of a telecom service and how a telecom provider is selectively being prejudiced, I have no idea. I mean, this is the idea. I mean, in fact, there's a very strong argument to be made that freeze and frost laws were put into place to protect fiber that's in the rights of way during that very sensitive time of the year when things are falling and heavy loads could result in things being cracked or crunched. The example that they gave from South Carolina was a hurricane path law. They said that places like Myrtle Beach that would prohibit construction in the rights of way during hurricane season, thereby taking one of two lanes away during the height of a natural disaster. Those things really are bad because they serve to deter the deployment of telecommunication services. Again, this idea that telecom outweighs public safety, at least in this example, is very, very troublesome. It was effective immediately, and this is subject to appeal in the Ninth Circuit right now under a case that was brought by the city of Portland. These cases have now been consolidated, and we'll talk about that in just a little bit. So again, what is a moratoria? An express moratoria is a state or local statute or other written requirement that expressly, by their very terms, prevent or suspend the acceptance, processing, or approval of applications or permits necessary for deploying telecommunications and/or facilities. The reference there is to paragraph 135. Well, here's a problem. That they then cite as an example that local governments are wrong if they refuse to accept a new application until the old application has been paid for. I don't know how that works. So a lot of times I'm going to be able to share with you the rules. I can't share with you the logic because I don't understand it myself. A de facto moratorium is when a state or local action that are not expressly made but effectively halt or suspend the acceptance, processing, or approval of applications or permits for telecom services. So again, that might be where it's unwritten, but in the city of Boston, there's the tradition, and I suspect the rest of the folks that are sponsoring the program today, the Northern New England folks have the same issues, and that is there are certain times of the month, certain times of the year, we're probably really not going to process applications to dig in the right way because the rights of way is frozen, and it would cause more damage than we can anticipate. That might be considered a de facto moratoria, and how we work through that is really very much still to be seen. Did want to point out that the order makes clear, or at least it references, that not all street cut regulations are in the legal moratoria. They point out that street cut requirements, which are designed to promote dig once policies, would not qualify as an unlawful moratoria if the state or locality imposing such street cut requirements does not bar alternative means of deployment, such as aerial lines or sublicensing existing underground conduits. So if I'm a planner and I want to have some sort of street cut regulation, the first thing I want to do is I want to put it under the rubric of a dig once policy, because you can point to this order saying that dig once policies are protected. And I also want to make sure that I've got alternatives for folks to be able to deploy during the times when I might not want the street to be cut. That is, perhaps deployed temporarily, aerially, or have underground conduits that folks have access to. So again, that's the moratorium order. Here are a couple of suggestions. Again, Ben tells me that this PowerPoint will be on the Ohio chapter's website, as well as it'll be available on YouTube. And so when I skip whole pages, it's not because I'm doing it intentionally or I don't understand that there's not good stuff there, but it's stuff that you can read for yourself and you can come back and capture. I just want to make sure that we get to the end of the program and get to your questions. So now I want to talk about the small cell order. The small cell order is this order for September the 26th. This is the one that most of you think of when you're thinking about the small cell orders from the FCC. There are 5 elements of this small cell order. One, and perhaps most importantly, the overarching legal theory is that it interprets the expression to prohibit or effectively prohibit which you can be found in section 253 and 332, to mean materially inhibit. So let's see if we can't put that in English. Section 253A says that a state and local government may not prohibit or effectively prohibit any entity from the provision of interstate or intrastate telecommunication services. We've had years and years of court cases trying to define what prohibit or effectively prohibit means. And in the very beginning of those court cases, there was a case that came out of California called California Payphone that established the standard that if you materially inhibit, then that's sufficient. The Ninth Circuit has spent the last 20 years coming to grips with how wrong they were with materially inhibit as the standard, and that's no longer the standard in the Ninth Circuit. So you've got this interesting thing happening. You have the FCC creating a legal standard based upon a court case that the Circuit Court of Appeals that issued that court case has since repudiated, has since rejected. That is the reason why we fought very hard to be in the Ninth Circuit, because we want to go back to the Ninth Circuit and say, you know, they're not benefiting, they're being hardheads, they're not listening to what you learned over the years, that it's just really impossible to understand what materially inhibit means. It can really mean anything. And if it can mean anything, I mean, for instance, if I have to have a permit to deploy services within a community, is applying for a permit and paying for the permit, is that materially inhibiting the deployment? Well, it could be, but it's not prohibiting or effectively prohibiting, because all you have to do is get the permit and pay for it and comply with it, and we're making everybody do that. So we're not singling you out, and we're not singling out telecom providers as opposed to other rights-of-way infrastructure providers, because they all need permits. And so that's why we're very, very troubled with the first part of the order, which establishes this new legal standard to define what Congress said, prohibit or effectively prohibit, for the FCC to say you can meet that standard if you can show that the requirement materially inhibits their ability to provide service. And then it builds on this materially inhibit standard, right? It creates tests to see whether or not local government action exceeds that materially inhibit standard. So it opposes that test when we establish for fees, aesthetics, undergrounding, and spacing, act in a timely manner, and other requirements that you would have typically on a wireless deployment, either inside or outside of the rights of way. So if any of those standards arise to the level of materially inhibit, and again, I can't tell you what that is because the commission doesn't tell us that, and that's one of the reasons that we're in the Ninth Circuit, you may be found to be in fact violating Section 332 and or Section 253, and be required to comply with whatever a court tells you have to do. The next thing it does is it takes materially inhibit and it applies it to the financial side, the financial obligations of a right-of-way deployment. And there are two sides to that, right? There's the regulatory side, and then there's the rental side. And what this order does is it creates cost caps. Now, I want to be very clear when I say cost caps. I'm about to tell you numbers, but the numbers aren't the cost cap. The cost cap is the recovery of your reasonable expenses, right? It's not the $270, or the $100 per an application. The cost cap is the recovery of your reasonable expenses. That's the cost cap. And it's the same thing. Most important for everybody to note, it caps rent within the right of way. Do not allow any of these folks to come to your community and say that they're now allowed on City Hall, or they're allowed on the water tower, or they're allowed on any of your buildings that you make available for wireless deployment, small cell or not, and that they now have a cost cap with respect to the rent that they have to pay for that. That's not the case. There is no cost cap on rents outside of the rights of way. So please make sure that you understand that. And even as I say that, I have to drop a footnote, but you're going to check to see what your state law says as well, because it may do that. And then the last thing that the order does is it creates two new shot clocks for small cells. And we're going to talk, it's a shot clock in terms of whether or not the application is complete. And then it's going to be a shot clock for when you have to allow someone to deploy. So that's where we are. I don't know if I can find out why is my screen not going to the next slide. All right. One of the troublesome things, and if you've ever heard me do this presentation in the past, and I've done it for APA in the past, one of the things I've always said to you is do the very best that you can to get a small cell or any sort of a wireless deployment to get them to deploy onto your property. And the reason I've always said that is because your rights to regulate that site as a landlord are significantly greater than your rights as a regulator. Well, the FCC, it's almost as if they were sitting there listening to my presentations, because they knocked the pins right out from underneath of me. Because what they say is that Congress did not include a blanket proprietary exception to 253A. Again, that's the prohibit or effectively prohibit, and for governmental property. And so the idea that somehow the FCC can come in and create a price cap on the use of our property and not be exempted under sort of the right-of-way reservation of this section 253C of it is very troublesome. And again, one of the reasons that we are appealing the order. Now, I will tell you, there's a difference here between our rights vis-a-vis FCC and our rights vis-a-vis the state legislatures, right? We have more protection against the FCC than we do against the state legislatures. And I would encourage you all to talk to your city attorneys, your county attorneys, your village council. We are protected under the Constitution just like any other individual, right? In the Fifth Amendment, that you can't take our property away unless it's for a public purpose and we're given just compensation, right? They're not allowed to do that. But the states are the creators of local governments. And so there's typically not a constitutional or statutory argument against what a state might do. So a lot of the rights that we have vis-a-vis the FCC, we don't necessarily have vis-a-vis the state legislature. So that's why it's vitally important that if there's state legislation being considered in your state, do everything you can to defeat it, because the ability for us to challenge it in court is much, much tougher. Now, there's an exception to that. In Texas, the Texas Constitution has got a couple terms in it that the city of McAllen right now is challenging the small cell law of Texas under those. Interesting. It's part of it's the difference between Texas and where you are, Ben, in New England, right? Because in Texas, cities existed before the state of Texas did. And so when the Constitution for Texas was written, it had to recognize that there were some pre-existing communities that had rights and privileges that needed to be protected. Whereas most of the cities and other entities in New England sort of came along with the colonies, et cetera. Although you will find some home rule protections for places like Boston. So again, we're back to the 5 elements, right? Well, we no longer have the proprietary exemption. The industry asked for a deemed granted remedy, and the FCC, I think, properly understood that they didn't have the legal authority to grant that here. They found that they had the right to grant it in the 6409, or as a small cell or an eligible facilities request co-location, but they didn't have it here because Congress was very clear in Section 332 that any appeals of decisions made by local governments remained the sole and exclusive jurisdiction of the courts. And then the last thing it does, and maybe this is esoteric on my part, but I think planners will agree with me that it's important to understand this. This order redefines the word co-location. historically, and again, you guys know this and gals know this so much better than I do, but historically, the idea of co-location was to capture a site where there was already a permitted wireless device present, right? So the city or the local government had already seen that site and had already touched it with its regulatory oversight and granted permission. And so a co-location was an addition to that. That's where 6409 comes from, the eligible facilities request. To be an eligible facility request, you have to start with there being an existing site already there, the idea of co-location. Okay, against that historic backdrop and understanding, the FCC introduces significant uncertainty and confusion because they redefine co-location for purposes of this order to mean that there is existing vertical infrastructure in place, regardless of whether there's anything on it. And if there's an existing tower or pole or vertical infrastructure, again, just to capture every possibility and permutation, that's considered a co-location. So again, it's the what we would call the base or the tower or the vertical infrastructure that establishes whether or not there's a co-location, not that there's already a permitted location, a permitted device there. And that's vitally important, and you need to keep that in mind as we move forward, because otherwise you can get confused, and I'll try to remind us of that different rule as we do go forward. So naturally, one of the first things that we need to do is we need to define, well, what is a small cell? And this is where we're going to start immediately with the discipline. What is a small cell? Well, before I can answer that question, I have to determine whether or not my state has passed a small cell law. Because if it has, then that's the definition that's going to govern, unless it's even smaller than this definition. And let me save you all the time for research. There isn't anyone that's smaller. In fact, the biggest difference between the FCC's definition and 90% of the state laws is that the FCC says, other than the antennas, which can be no more than 3 cubic feet in volume. By the way, there's no limit on the number of antennas. Other than that, everything else has to fit within 28 cubic feet in volume. If you look at your state laws, most of them say something similar to that, but then they add on, but not counting, and then list about 10 or 15 different things, whether it be the wiring or the power or the different boxes and fuses and things along those lines, that engineers tell me probably result in at least another 10 cubic feet. So when you look at your state law and it says no more than 28 cubic feet in volume, not counting XYZ, really what you're talking about is somewhere closer to 38 cubic feet. Also, in a number of the states, whereas the FCC rule is no more than 3 cubic feet in volume, a number of your states will be 6 cubic feet in volume. Oh, I'm sorry. The other thing that a lot of the states do is they exempt any of the materials that you're requiring for screening or camouflage, whereas the FCC, everything associated with it has to fit within the 28 cubic feet. So in a sense, the FCC's is much more preferable than a great many of your state laws. The difficulty is that the engineers tell us that 28 cubic feet is still way too big for what people can do. That the size in the marketplace today, the engineering out there is so much more, can be so much more efficient. Then you also are looking at mounted on structures 50 feet or less in height, including their antennas, or mounted on structures no more than 10% taller than any adjacent structures. And 3, they do not extend existing structures on which they are located to a height more than 50 feet or by more than 10%, whichever is greater. So again, you now have this idea of the definition, but again, from a discipline standpoint, the first thing we're doing is we're checking to see whether or not our state has acted. this slide I'm throwing in here because an awful lot of times we tell folks be very wary of RF issues, and because we are specifically precluded from doing much more than enforcing the FCC's RF standards. But even in enforcing the FCC's RF standards, there's work to be done. And this was from a chart that was done on a wireless deployment up on a rooftop. And there are additional steps that can be taken here, because if you look at this, you'll see that there are areas that exceed the occupational, there are areas that exceed the public, and again, there are things that you can do to protect yourself. Mike Lynch, who is the head of the broadband office in Boston, loves to tell the story about how he was out doing a small cell public meeting. And he had the people from, and I won't mention the company's name, telling people how these things are very, very safe and they don't pose any threat whatsoever, and people should stop worrying about them, despite the fact that they might be, 40 feet from a bedroom window that happens to be a nursery. And so he said he sat this whole evening hearing all this stuff and made a lot of sense. And then the next day he was called out to look at a job. And there was a fellow there from that same company who needed to climb up and fix something on a pole. And the fellow waited for 4 hours because he needed somebody to come in and shut down the small cell site, because there was no way in heck he was going up there with the RF threat. So Mike says that, those are the types of stories that people hear on a regular basis, and they really are troubled by it. I will tell you that Montgomery County, Maryland, in the appeal of the September order, did take on the RF issue, and that will be briefed before the Ninth Circuit as we move forward. Okay, so moving further, and what we're doing is we're just drilling down little by little on the order and what it says. So this redefinition of effective prohibition, that is the materially inhibit, what it does is the commission said that the courts in their prior approaches, they erred, because what they said was, well, you need to show us that there's a coverage gap. And if there's a coverage gap, then you need to be able to show us that the way you're going to deploy is the least intrusive alternative. And again, an awful lot of this stuff is won by the lawyers, but the ideas were generated by you planners. These were the arguments that you armed us with when we went to court. And again, we think that we came out with a pretty good answer, right? Do I get to put this up? Well, I don't know. Can you show that there's a significant gap? Okay, you can show there's a significant gap. Now I want you to show me that you can meet or close that gap in the least intrusive means, or least intrusive alternative. That's pretty good, right? There's some objective standards there. FCC throws them out and says that that's an error, that's wrong. They say that a state or a local legal requirement constitutes an effective prohibition if it materially limits or inhibits the ability of any competitor or potential competitor to compete in a fair and balanced legal and regulatory environment. And that's quoting from that California payphone case I talked to you about, that, as I said, the Ninth Circuit has repudiated. Right? The people that wrote it say that that test is not workable, but the FCC wants to quote it and say that that's the standard. And then they go on to say, we clarify that an effective prohibition occurs where a state or local legal requirement materially inhibits a provider's ability to engage in any of a variety of activities related to its provision of a covered service. This test is met only when filling a coverage gap. This test is not only when filling a coverage gap, but also when densifying a wireless network, introducing new services, or otherwise improving service capabilities, also by materially inhibiting the introduction of new services or the improvement of existing services. All right, again, what does all that mean? That means that I could have 5 bars from my company, and that company can still come in and say, the 5 bars isn't enough because we need to introduce these new services, and they're going to eat up that 5 bars. So there are challenges ahead of us, but we need to recognize the thumb is very much on the scale of the carriers under this FCC order, and that's why we had to challenge it. So now we're going to go back to fees, right? And now we're talking about, again, what is materially inhibit or reasonably materially inhibit when it comes to fees. And the court said, the FCC says that a fee is permitted, and again, here's the cost cap, if it is a reasonable approximation of the state or local government's costs. And then they drill down even further and say only objectively reasonable costs are factored into those fees. And 3, fees are no higher than the fees charged to similarly situated competitors in similar situations. So what does that mean? That means that if you're the city of Burlington, and I'm making this up, I'm in Burlington, North Carolina. So if you're in the city of Burlington, North Carolina, and you use an outside engineering firm to review all of your cell site applications because you're a smaller community and it's just cheaper to do it that way, and your idea is that the fees are really nothing more than a reimbursement of what you're paying for that engineering firm. Well, under this test, that's not automatic, because you're going to have to demonstrate that engineering firm is charging you objectively reasonable prices. And so how do you do that? Maybe you do that through your procurement process. Maybe you do that through other benchmarking. But understand that the onus is on you, local government, to show that it's an objectively reasonable cost. And then the second thing is that, and then you have to show that you're charging the same thing for similarly situated competitors in similar situations. And again, have we seen any court cases define this yet? No. But again, that's the test. So that's how your fees work. And fees include both one-time and recurring charges that are made by state and local governments. And so what that might be, that could be application fees, hearing fees, appeals fees, permit issuances, plan check fees, inspection fees, et cetera. All that you can recover your reasonable approximation of your cost, so long as your costs are objectively reasonable and they are no higher than what you are charging similarly situated competitors in similar situations. And so then the commission creates sort of safe harbors or reasonable fees. And I put there, caveat, check your state laws, because a lot of your states allow you to collect a whole heck of a lot less. But the FCC says that a $500 application for the initial application that could include up to 5 nodes or 5 wireless sites it's a safe harbor, and then you can charge $100 more for each additional site. If they want to put a new pole in, $1,000 fee is reasonable. If you want to then charge for the rent for that being in the rights of way, $270 per facility, including, and that includes a right-of-way fee, and or a fee for attachment to municipal infrastructure is $270. It specifically rejects the claim that localities are exempt from Section 253C's fair and reasonable standard in setting rates for right-of-way infrastructure. Again, traditionally, this is where I always wanted you to be. I wanted you to say, put them on your property, and under 253C, you're entitled as a reasonable standard, fair and reasonable compensation, or market rate compensation. This is specifically rejected as we move forward. Then the commission drills down a little bit and talks about, well, in existing agreements, all existing agreements are not dead on arrival. They have to be read on a one-by-one basis, and I think that this has proved very helpful for a number of cities that were early to move. And so, again, don't let somebody come in and tell you that your existing agreements are null and void because of the FCC order. No, paragraph 66 makes it clear that they are not null and void. They're not dead on arrival. They're going to be reviewed each on an individual basis. So we're going through now on the deepest level, right? We started off by talking about how materially inhibit was the new standard. We talked about materially inhibit with respect to the cost, whether it be one-time or annual cost. Now we're going to talk about materially inhibit in terms of what we can require for aesthetics. And an aesthetic requirement, the order says, is not preempted if it's reasonable. It's no more burdensome than those applied to other types of infrastructure deployments. So the difference between fees and aesthetics is that fees are applied to competitors in similarly situated circumstances. Aesthetics are applied to anyone in the rights of way, any types of infrastructure deployments in the rights of way. I think that's significantly enhanced. It probably makes it even harder for us. They have to be objective, and then I think maybe I should split this out, the 4-part test, and they have to be published in advance. Now, I know a lot of you were on this call today because the deadline for publishing in advance was April the 15th, but even in the way I said that, I'm wrong. We had until April the 15th to put aesthetic standards in place to be defended. That doesn't mean now that we are past April 15th that you're done, that you can't do it now, okay? If an application came in today, you'd have a hard time applying aesthetic standards to it if you hadn't already published something. But if something comes in next week and you put something in place today, what you put in place today is in fact equally enforceable against that new application. Alrighty? So when you do it, they have to be reasonable, no more burdensome than those applied to other types of infrastructure deployments, and they have to be objective and published in advance. What the commission says, Ben, I'm just doing a sound check. Everything's still okay?
Yeah, you've been cutting in and out a couple times about 10 minutes ago, but I think things are okay now.
Okay, thanks. Yeah, for some reason I'm getting sort of flashes on the phone. Sorry about that. Aesthetic requirements that are reasonable and that they are technically feasible and reasonably directed to avoiding or remedying the intangible public harm of unsightliness or out-of-category deployments are also permissible. So you can focus on style. I think the bottom line on all this is that the standard's going to be based on costs. I do. I think so that if you can show that it's reasonable cost, I think you're going to be able to defend anything. Undergrounding is the exact same test, same criteria as aesthetics general. That is it reasonable, no more burdensome than those applied to other types of infrastructure deployments? And here, this is really important, right? I mean, you can't ask a new small cell to put everything underground or not be allowed into a community because you're not allowing anything that's not undergrounded. And then you've got 3 other providers that are deployed aerially, right? I mean, there's a little, they're not all wrong, right? I mean, I think sometimes we have to do this. And again, objective and published in advance. Spacing requirements, right? So undergrounding, we all understand. Spacing is, well, how far apart can we put these things? And that's going to be a real challenge because we keep being told by the providers that they don't want to share space. They all want their own pole. And if they need their own pole every 500 feet, and there are 4 of them, right? Verizon, AT&T, Sprint, and T-Mobile. I mean, if each of them want their own pole, does that mean we've got new? And that's not even counting in the team. That's not even counting in the Crown Castles, the Extonets, the Mobilities, the infrastructure providers. I mean, are we taking away streets and creating picket fences? That's going to be a real challenge for you all in the planning community. But again, the idea here is that a minimum spacing requirement that has the effect of materially inhibiting wireless service would be considered an effective prohibition of service. So we're in the same sort of category. You've got to show that what you're doing is reasonable, that it's published, that you're applying it to others, and when all is said and done, you also have to make sure that you are not rising to the level of an effective prohibition of service. So we talked about the other things, and I said that there were 2 new shot clocks that were created. So let's now go through these standards, right? The shot clocks apply to all permits required for deployment, not just wireless permits, right? So I think we miss it, and it means everything has to be done, including appeals. So I guess our bottom line, and John Gasparini, if I say anything wrong here, I really need you to jump in. But I think where we are, when all is said and done, we think that you need to put processes in place that can move forward on an administrative type basis, and do it so that to the greatest extent possible, you preserve the ability of the public to be heard. But the idea that we're going to have significant public involvement is really going to be a great challenge moving forward. We fought for that. It's one of the point down on appeal, but these rules were really created to push public hearings out of the process. Another thing that a lot of you planners had developed, and it was brilliant. It was a way of telling people, hey, why don't you come in before you file your application? We can talk this thing through, and we can figure it out. Well, the industry went to the FCC and said, oh, they're giving us a hard time now. They're making these pre-application meetings mandatory, and it's their way of extending the shot clock. And so what the order says is that if you have a mandatory pre-application meeting, that date is what starts the shot clock. Just killer. And failure to meet shot clocks is deemed an effective prohibition, but there is no deemed granted relief. What they can do is the carrier takes the FCC declared effective prohibition standard to court and asks the court to enforce it, but it's not deemed granted. They actually have to get a court to do something. Batched applications, we have to accept them. The time frame for one is the same as it is for 100. So if Burlington, North Carolina, were to get 50 applications tomorrow, and they were all for small cells on existing poles, then all those would be subject to a 60-day shot clock. If the city got 50 applications and 49 of them were for deployments on existing poles, and one was for a new pole, then all 50 would be subject to the 90-day shot clock for going on a new pole. Because if you put it all in one batch, each batch gets the same amount of time, and it's always going to be the longest amount of time any one application in that batch has. The commission says, and it's really interesting, because there was an argument by the commissioners the day that they issued the order, with one commissioner saying that he really didn't like the idea that there was an out for the shot clock for batches. And you read the order, there's really not an out. There's a suggestion. And I think what happened is they probably cut it out at the last minute. It says, in extraordinary cases, the citing authority can rebut the presumption of reasonableness of the applicable shot clock period where a batch application causes legitimate overload on the citing authority's resources. Doesn't say how much extra time you get, doesn't say how you go about establishing that. So I don't know that I would even advise anyone to try to pursue it, because by the amount of time you're going to do in trying to seek the extension, if the FCC doesn't want to, they don't have to give it to you. I still find, and it'll be interesting in the question and answer period, if anyone disagrees with this statement, I still find that most carriers understand that unless they work with the planning commission, they're still not going to get it done, and they'll give you reasonable extensions of time. I think don't stop asking for those, because I find that people are getting them. And then there's a new shot clock reset for the small cells. I'm not going to waste any time because I don't want to. Just know that it's there. It's not there. We talked about the two meanings for colocation. Here it is. It's just in English. I already explained it to you better that way. We talked about access to local property and how, in fact, you don't get any special protection because it's on your property anymore. So again, all of you that have listened to me in the past, reject or forget what I said because the commission took my arguments right out from underneath of me. Here's where I wanted to get. I figure if you can't put it on one slide, then shame on you. So these are the new time frames. This is the new shot clocks that you have to live with. And if you don't have this on a wall somewhere, then do so. If we're moving from left to right, the first thing I want to point out to all of you, and since I had my 61st birthday yesterday, I can include myself in the old timer group, right? Old timers that are on this call, remember that the shot clock, or that the timetable would run from the submission of a completed application. That's not the case anymore, right? That timeline starts with the filing of an application, not a complete application, an application, all right? And then you have 10 days. You have 10 days to determine whether or not, if it's a small cell, whether or not that application is complete. If that application is not materially complete, you can send it back and tell them start all over again. That's the reset. 30 days is the traditional time frame for determining whether or not an application is complete. And that's still the same, but you've got the 10 days for the small cell. So the most important thing that all of you have to ask right up front, or you need the applicant to declare right up front, is whether or not it is a small cell application. Is it a small cell? Is it an eligible facilities request? That's 6409. Or is it just a regular 332 cell application or 332 cell co-location? The timeline above, the 10-day review of amended applications, that's sort of the shot clock within the shot clock. If I'm on day 29 of a non-small cell application that I've received and I hand it back and it's incomplete, when that comes to me, I only have 10 days to see what, I'm sorry, let me read. I returned a non-small cell application on day 9 for incompleteness. And they come back to me on day 15 with an amended application. Well, I don't have till day 30. I only have till day 25 because the interim or the amended application is limited to 10 days. The other thing that we have to remember is that you get one bite at the apple. When you tell an applicant that their small cell application is incomplete, you need to list everything that's missing. Because if you list A through J, and they come back with A through J, and you decide, oh, because of the answer to J, they now owe you O, you can't ask for O. You can't ask for an O, and you cannot deny that application based on incompleteness. You can deny it on other grounds, but you can't deny for incompleteness. So again, one bite of the apple, 10-day amended rule. And then you can, the rest of it is sort of self-explanatory. The status of the appeals, you knew that the order went effective on January the 14th. Monday of this week was when aesthetics and design standards could be defended under needed to be defended under the SCC's test. But there's no rule or limitation on you adding it on now. So please do that if you haven't. The appeals are ongoing. Let me see if I can do this all really. We filed appeals in both the moratorium and on the September order. The American Public Power Association filed an appeal of the one-touch section of the moratorium order. All those were consolidated. There was a lottery. It went to the 10th Circuit. We petitioned the 10th Circuit to remand everything to the 9th Circuit because that's where the Portland appeal was. We were successful. Again, we celebrate. That's where we wanted to be. Why is that? Because I explained to you the California payphone case, which is the basis for this whole order, has been repudiated by the Ninth Circuit. That's why we want to be in the Ninth Circuit. Yesterday, the Ninth Circuit held a case management conference. It was very good for us. The commission has been trying to slow roll and not get around to this appeal. The case management court said that our briefs are due on June the 10th. The FCC has 20 days in which to send the record up, and this matter is moving forward. It is not unreasonable to believe that we will have a decision before the year is out, and that's been our goal all along, to try to get the decision as quickly as we possibly can. There's a problem in that we've got these petitions for reconsideration that are pending, but again, I think the court sort of pushed it along a little bit yesterday, and so we'll see what happens with these recons. We've just spent the last hour talking about how we're going to overturn this, or attempt to overturn this in litigation. There is a way to do it in legislation. There's a bill, H.R. 530, that was introduced by by Representative Anna Eshoo from California. As of yesterday, it had 41 sponsors. We would love to have your member of Congress join. It basically resets the clock. It overturns the moratorium order, and it overturns the small cell order. So it would turn the clock back to August the 2nd, 2019, and we would move on from there. Senator Feinstein of California, Blumenthal of Connecticut, and others have pledged to introduce a Senate companion. Again, anything that anyone out there that can do to help. You can work with your League of Cities or the Conference of Mayors and National Association of Counties in trying to move this all forward. I'm sorry, it would set it back to August of 2018. We haven't gotten to August of 2019, excuse me. Small cells in the rights-of-way laws. This is a chart that's already dated. We now have a South Carolina law that's being developed. Georgia has been passed. So again, almost half of you have state laws that you have to comply with. Please, 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 please check with your state law before you do anything. And everything that I just said is subject to preemption by the state law, and preemption is not the exact term, I apologize, but it's subject to being bumped by what it's there. We've got some practical suggestions here. Again, I'm going to leave these for you all to be able to go through on your own, because not everybody agrees with what I say. But again, check with your state law at all time. I did want to point out to you that that there are two additional threats at the FCC right now. One would be to allow all in-kind contributions to be counted as franchise fees. And what is that? What's an in-kind contribution? Well, things like institutional networks and complementary cable service, your PEG channels, the value of the channel, electronic programming, video on demand, customer service, video transmission, discounted enterprises or discounted for seniors, right-of-way requirements such as relocation, restoration, maintenance, undergrounding. All these things the cable is asking the FCC to say ought to be offset against the franchise fee. We are clearly opposing that. We've got a large coalition that's moving forward. Again, it would be helpful if you could advocate at the FCC by filing ex partes or educating your elected officials and the public on what a bad idea this is. And then there's a new rule, a notice of proposed rulemaking that was approved by the commission last week. It's going to go out for public comment. It hasn't been in the Federal Register now. But what it does is it would expand the OTARD rules, that is the rules that exempt from zoning and any other regulation over-the-air reception devices. It would like to extend that now to antennas that would operate primarily as hub or relay antennas. It's basically a backdoor way of extending the escaping zoning and planning oversight outside of the rights of way. And this is very troublesome, and it would be great. As I said, this has not been published in the Federal Register yet. When it is published, we'll have 30 days to file comments, and then 15 days after that to file reply comments. But again, it would be great if APA could review this and provide us lawyers with insights as to how troublesome this is and how it would be very damaging to local government, to planning process, to community aesthetics. That would be really, really appreciated. As I said, comments are due 30 days after publication in the Federal Register. Reply comments will be due 45 days, so 15 days later. So we'll take your questions, and that's me if you need me. I apologize. I know that there was way too much there, but again, the goal here was to get everything done and have questions starting at 2 o'clock, and so it's 2 o'clock now, or 2:01. So let's go with it. How can I help you?
Hey, Jerry, that was pretty remarkable how you powered through all that, and you did finish right on time. And happy birthday. So we have as we anticipated, we have a ton of questions, but I want to start with a couple. One is there a model state law that exists, or is there an existing state law that you would consider to be a model you could point us to?
Yes, absolutely. California, Maryland, New York, all those states that haven't passed a state law are the model state laws. There's no need for state legislation. There's absolutely no need for state legislation. None.
Okay, that's good advice. And with regard to
Ben, I won't be such a smart aleck. Let me explain that a little more. And again, this is no insult to the people of Kansas or Missouri or Florida, but in 2005, states were told that if you get rid of local cable franchising, we will expedite the deployment of broadband to your community. We will lower prices. We will give more people jobs, and we'll have better quality service. And so a number of states did that, and a number of states said, you know what, we don't believe it. And if you look at FCC statistics today, the states that reserve for local government the right to franchise cable operations have more higher broadband deployment than states that took it away. And if you look at the number of states where there are multiple providers offering competition or competitive choice, you will find that the most states with the most competition are states where local franchising ruled the day, and they rejected state franchising. It's in the same thing now. We're now in year 4 of passing small cell bills. The state of Texas was one of the first to do it. Florida was close in behind. And then there have been, as I said, you can look at the map. Are you trying to tell me that New York City doesn't have more deployment of small cells, or Montgomery County, Maryland, or Baltimore, or anywhere in California? And yet every one of those states has one thing in common. They have rejected state small cells. Why are they deploying small cells there? Because that's where the market is. And that's the truth, and that's what's always going to be the truth, is that the industry will go where the market is. The regulations and the impact just don't mean that big a deal. So that's why I say the model state law is no state law.
Okay, sounds good. And with regard to HR 530, is there a model letter to members of Congress that you could point us to?
Yeah, it says, Dear Congressman, please co-sponsor HR 530 to return to local government oversight authority.
Okay.
Yeah, no, it's, yeah. And by the way, NLC, Conference of Mayors, NACO, they all have models that they can share with you.
And everyone should encourage their own state leagues to do the same. So we have a ton of questions, so let's get to them. One is, it's cast as a Massachusetts question, and this is from Marin, but I think it can be generalized. And she asks, Do you recommend a municipality address small cell installation in a zoning bylaw or ordinance or a general bylaw? So is this a zoning question or is it a general police power question?
Well, again, the answer to that's going to be, what has your city done? What has your community done with respect to your rights of way? If you extend zoning to your rights of way, then you can do it as a zoning matter. Most people, I don't believe, have extended zoning into the rights of way, and therefore it's a police powers matter. By the way, again, I wish my colleague John Gasparini weren't ill, but John would remind us all that when the FCC rules say that things have to be published, that does not mean it has to be in an ordinance, right? It can simply be on your web page, or it can be part of your application. And so when we say things have to be published, please don't think that it has to be in your ordinance. And in fact, one of the things that we try to counsel people is not to put the FCC rules or the state law into your ordinance. Just say in your ordinance that, the city or county or village will act, in compliance with all applicable law. Because if things change, we don't want you to forget to go back and change your own law and then wind up being hung up not by a federal rule, but by your own rule. So, so to get back to the original question, consult with your city attorney on how they believe, how she believes it should best be done. But a lot of times it's going to turn on what your existing rules are in terms of whether or not your zoning applies to the rights of way. Again, my own personal
Jerry,
prejudice.
I'll tag in for one more note too.
Oh, go, John.
The big fact, one of the other big factors to consider is quite simply time. Even in communities where we've seen small cells governed by zoning previously, we've had a number of communities recognize that you can't really do if you have a process that requires, for example, all your wireless facilities to get a variance from a zoning board, it's really hard to do that in 60 days. It's really, really hard to do, right? Receive the application, have your staff do their staff work, notice a hearing, have the public hearing, all these various steps. It's hard to do. We see a lot of communities preferring to use something like encroachment permitting or, another type of permitting in their general ordinances rather than zoning specifically, even if they've been using a zoning approach, simply because there isn't enough time. You just can't get it done.
Yeah.
And what about
the idea is, zoning was created to make sure there was community input, and the FCC has really made that almost impossible. Go ahead, Ben. You keep trying to ask a question.
So adding to that, John and Jerry, I should think that the 10-day shot clock for review of completeness would be almost impossible for a board that doesn't have professional staff in a small community, for example.
Yeah, does the board typically have to determine whether or not something is complete or not, or increasingly the answer for that is to have the application done online. And then the machine tells you that there's a line missing, and then there's human follow-up to see whether or not there's gibberish in the lines that were typed in. But I didn't realize that boards have to determine whether an application is incomplete. I thought professional staff typically was authorized to make that determination.
That's probably based on that's a jurisdictional question, under state law.
Okay. Yeah.
So we've got a question here from Joe, and he asks, has anyone in the FHWA, Federal Highways, raised concerns that the rent caps effectively give away federal highway right-of-way at less than fair market value?
Oh, man.
I was worried because when you said Joe, I was scared to death it was Joe Van Eaton that was throwing in hard questions, and then this other Joe comes up with a hard question. Joe, that's a great question, and it gives me a chance to tease our friends on the state highway. So this law does not apply to federal property. The FCC doesn't have the authority to tell the FHWA what they're allowed to and not allowed to charge. They're not allowed to do that. Now, President Trump has been working very aggressively to try and get the Department of the Interior and the Department of Defense to open up, and also working with GSA. But so it doesn't apply to FHWA. Here's the interesting point, though, that your question raises, Joe. In an awful lot of the state laws, because we all know that state highway departments, rule the roost in state capitals, in almost every one of those state laws, the DOT was exempted. They got themselves exempted when these caps were put in, but now they're finding that they have to deal with them because they're not exempt under the FCC's rule. The FCC rule applies to all state and local property. And so you're exactly correct that the numbers are not large at all. But again, the 270 is a safe harbor. It's a stand-in. If you can document that your reasonable approximation of your cost is greater than the 270, you can charge that, again, if you haven't already been capped by state law.
Okay, we've got I would say, a particularly technical question from Karine regarding element number 5 of FCC 18-133. Does colocation definition also apply to Spectrum Act colocation, or do those remain separate kinds of facilities?
Yeah, why don't we put that in English for everybody?
Please.
Yeah, and is it Corinne, did you say? What's the question? And Karine, if I translate this wrong, somehow let Ben know. So, as I said, there are two meanings to the word co-location now. There's co-location in the sense of a small cell that can be deployed within 60 days in the rights of way if it's being deployed on an existing vertical infrastructure. That's that co-location. The other, and so now the Spectrum Act co-location, I think what Corinne is referred to, is that the Spectrum Act or the or ARRA, the stimulus package, etc. There was section 6409 of that bill that talked about eligible facilities request. That is a co-location that does not change the character of the structure. And there are tests for what it has to meet in terms of size and whether or not it has excavations, whether or not it offends any screening requirements. And so that's a different co-location. That's an eligible facilities request. And so, yes, that is different. And I thank you for your question because it highlights the need for us to understand that there is two meanings for the word co-location now in the planning world, and each of them have different implications. By the way, as John and I and our colleagues at BBK have been helping local governments around the country update their ordinances, their codes, their administrative processes, the one thing that we have found, one consistent thing that we have found, is that very few folks updated their rules to address that Spectrum Act co-location, that 6409 co-location. And so we find ourselves sort of adding things in with respect to eligible facilities requests. So if you've got to check your rules, you should be checking to see whether or not you have addressed 6409 in them and that shortened shot clock that deals with those, because you've got 60 days in which to deal with an eligible facilities request. And if you fail to meet that standard, that's where the deemed granted comes in. And Ben, if I misunderstood Corinne's question, I hope she'll send something to you and we can go back to it.
Okay, and thanks.
Jerry, this is John. I'll jump in with one more note on that question too. I think it does add some confusion that the same word is used twice. One of the ways that's helped me a little bit to think about this is there are going to be some Spectrum Act or 6409 co-locations, or most, if not all of those, would likely also be small cell order co-locations, because the restrictions on what qualifies as a Spectrum Act relocation are narrower than what's in the FCC's recent order. But not all small cell co-locations from the September order are necessarily Spectrum Act co-locations. Jerry, does that sound right to you?
Yeah, exactly. And let me take it one more step, and the reason why that is, right? Because every 6409 co-location is always going to happen where there's an existing permanent wireless device, whereas the other ones, you don't have to have that. So that's the real difference.
And it will be important to be able to distinguish between the two on an ongoing basis, because as you all well know, those Spectrum Act or 6409 co-locations do have that "you must grant" language in them, you know, in the federal requirements, as opposed to these other small cells.
Okay, so we have a question from Lenore that actually reads like an essay question, so don't go wild on this, guys. And she asks, regulation on private property is an issue of rights, but is a wildly lucrative accessory for an owner to have on his or her property. Can you briefly comment on how regulation on private property melds or doesn't with the regulations we're discussing on public property?
Yeah, the first thing I would do is I would question the lucrative nature of that marketplace in the future. And the reason I say that is if I can get on a pole in the rights of way for $270 for the year, why do I want to go on to a parking lot's light stanchion where I might pay a couple $1,000s a year? And so I think that that's sort of point number one. Point number two is that if we could distinguish between inside and outside of the rights of way, I still think we can make generalized statements that local government property ought to be entitled to the same market forces and market value outside of the rights of way as private property outside of the rights of way. And anyone that comes in below market, you want to just tell them thanks, but no thanks. There is that difference. But I guess the last thing is that wireless deployments on private property still have to clear all of the rules and regulations that your community has for community aesthetics and again, I don't think that you should diminish those one bit. And in fact, because of 6409 and other co-location standards, I would hope that everyone is requiring some sort of stealth obligation or component in anything that's approved, so that because we now know that there's automatic growth patterns, the only way you can manage the automatic growth pattern is to start with a stealth requirement that has to be complied with as the facility grows.
Jerry, I think you had already answered this, but I just wanted to check and make sure. Sandra has a question, and she asks, what do you mean by published in advance? Do you mean that our code must reflect the aesthetic requirements for small cell sites? I think you had said it could just be a part of the application, though.
Sandra, thank you. You planted that question the exact way that I'd asked it to, because we can't say this enough. Published does not mean in your code. Published means that it's on paper, on a screen somewhere that you can point to when the application comes in and say, here's our standard, you don't speak to it. You got to be able to point to the standard. It's got to be there somewhere that you can point to it, because if you can't point to it, then you can't enforce it. So that's all we mean. And in fact, what we have tried to recommend to folks is that if you feel it necessary, empower your city planner or your public works director or your city engineer, empower him or her to develop these standards which would then become part of any application.
Great, thank you. And I think you partially answered this question as well, but I want to circle back to it. Aaron asks, does the FCC small cell order preempt cities from requiring cabinets located at the base of utility poles to be placed underground?
No, well, God forbid that any lawyer ever give a definitive answer. I almost violated all the rules. The answer is, and John, I want you to weigh in here. The answer is that there is nothing specifically in the order that prevents you from making that a requirement, so long as it does not arise to the level of prohibit or effectively prohibit the provisioning of services. I think that there are lots of things that you can point to, whether it's compliance with the ADA, whether it's compliance with federal highway safety standards for trying to reduce the number of structures on an adjacent pavement that a car can run into. So there are rules and regulations that exist already that you can enforce. You just want to make sure, though, that what you're requiring the wireless provider to do, you're requiring other folks, whether it's similarly situated competitors or other infrastructure providers in the rights of way. So you can't write a rule that says that the wireless provider has to go underground, but the cable provider can have a vertical, above ground infrastructure deployment, right next to it. That's going to get you in trouble. John, improve on that.
I think the best way to improve on that, frankly, it didn't leave me much room to improve on it. I think it's one of those things that's going to come down to the uniqueness of your community and not only to how you've previously handled other types of infrastructure, but also on your priorities moving forward. And that may vary from neighborhood to neighborhood. We see, for example, communities that are resort destinations that have placed a strong emphasis on tourism, being willing to push a little harder to require certain kinds of things, to require things like undergrounding for aesthetic reasons and for a variety of reasons. You see other communities that are, more that are less residential or have more commercial areas and things like that, where they don't feel that these things are as important, and so they don't want to push. It's all really a balance across the whole scope of your policy. And this is just one of those areas where you can kind of push and pull a little bit to figure out the right balance for your community. One of the things I think Jerry's emphasized throughout this is when we talk about, well, can I do this? Can I do that? There isn't a lot that the FCC says you outright cannot do. It's a question of what sort of degree of pressure against what the providers will demand are you willing to exert? They'll always demand as much as they possibly can. They'll come back and look at an FCC baseline rate, and they'll say that's too high, and they'll go to your state legislature and say it needs to be lower. They're never, ever going to be happy. So you'll have to decide for your community and yourselves where you want to draw those lines. We spend a lot of time, Jerry and I spend a lot of time helping communities think through that process. The undergrounding is one really good example of that sort of tension that you have to work out as you're figuring out these policies.
Okay, thanks. So we have a question here from Savannah. Can you clarify not deemed granted? Does this mean that if the shot clock runs out, that the provider still has an obligation to meet the city's ordinance to be able to co-locate, or will that be up to the court to decide?
I can't answer that question. I have to go to Savannah to do an insight visit to be able to answer one of the most beautiful cities in the world. Yeah, so sometimes I'm guilty of being glib. Maybe I was guilty. Let me see if I can answer this more clearly. Section 6409, that is the eligible facilities request, creates a standard, creates a new rule that if you fail to act within 60 days, the application is deemed granted. and then the applicant has to let you know that they're going to do that, and it moves forward in that sense. Under this new small cell test, if you're not a 6409 applicant, you're not an eligible facilities request, but you are, you're seeking a small cell deployment in the rights of way, and 60 days have come and gone, and the city of Savannah has not issued a grant or denial, then what happens is that the applicant would have to go to the local federal district court and say, so here's the document. We put the application in on day 1. It's now day 62. We've heard nothing from them. We've informed them, and so here's the complaint. And then what would happen is that Savannah could go to the federal court and say, we have no idea what the heck they're talking about. We have no records of receiving this application, or we received this application and here is the notice of incompleteness that we sent them that we haven't heard from. There was a case that was just handed down, and if you think that I'm kidding about the fact pattern, let me explain. There was a case that was just handed down up in, this was in New York, where someone made an application and it was denied, and while it was being denied, they put another application in, which was also denied. It was sort of rolled in, but then the carrier tried to say, well, no, this one wasn't denied. It's 61 days. It needs to be deemed granted, and the court basically laughed them out. But they were trying to do just that. They were trying to sort of go fast and furious with the facts. So that's what I mean by not deemed granted. It's the presumption is that you failed to act in a timely manner, right? Section 332C7 says that local governments have to act in a timely manner. We preserve our zoning authority, and then it has certain limitations, the biggest one being that we cannot result in actions that prohibit or effectively prohibit the provision of the covered services. But so that's what I mean. And Ben, if that's not clear, let me know, and I'll have John give it a shot.
That makes sense to me.
Okay.
John? Okay, we have a question from Laura that's kind of a practical science question. And she says, you mentioned that providers don't want to share space. They all want their own poles. Is it technically feasible for providers to share poles?
Oh, that's a fun one.
So who asked the question?
Laura,
that's such a perfect question, and please understand that I'm not being flippant when I give you this answer. The carriers tell us it doesn't work, but people like Extenet, Crown Castle, Mobility, American Tower, all of the carriers, all the folks that provide the facilities, they're staking their whole business plan on the ability of carriers to share space. So again, technically, I don't think there's anything that limits it. But right now, the carriers don't want to do that. I have my own theory on why they don't want to do that, and that is, I think that, and again, at the risk of getting in trouble with naming names, I don't think that the big guys, and you can define big guys however you want, I don't think that the big guys want to have their infrastructure investments help underwrite service by competitors, and that's why they want to do their own. They want to do their own deployments. If they come in with one of the carriers' carrier and make that possible, well, then that means their competitors are getting access to a marketplace at maybe a third of the price of entry that AT&T and Verizon are willing to commit to, and so that's what I think is going on. But I could be wrong.
And so last question.
I think
This
that's
is
the case
from,
as well. I would agree.
okay, this is from Jana, and she asks, in South Dakota, our municipal league with input of wireless industry representatives have developed a model small cell ordinance and are asking for the locals to adopt it. Should we hold up in adopting this given the status of the appeals?
Let me see if I can be guilty of following my own instructions. The first thing I'm going to check in, that is, what has my state law done? Has South Dakota passed a law? And if it has, then, you know, I want to make sure that whatever I do is consistent with South Dakota law, because South Dakota law will not be negatively impacted based upon these appeals of the FCC orders. So I would do that. Second thing I would do is I would tell anyone from South Dakota is more than welcome to write or call me at any time, because Chairman Thune of Senator Thune of South Dakota is probably, you know, one of the most important members of Congress that we have. He's no longer the chair of the Senate Commerce Committee, but he's still the chair of the subcommittee that deals with these issues, and he takes input from his home state as much, if not more, than any other member of Congress. So I am thrilled that there's somebody on here from South Dakota, and so that's what I would do. I tend to find that the industry proposals aren't horrendous, but what they do is they try to take all they resolve all issues in favor of the industry. And the other thing that they do is they move into code things that ought to be discretionary or at the call of professional staff. So they don't want to spend any time with the planners, they want to spend time with the mayor. And so so yeah, I think I'd hold off on developing anything, and I'd be more interested in having my code be compliant with South Dakota law than federal law, because I don't want to jinx us, but I think we're going to do okay in this lawsuit. I think at a minimum some things are going to get sent back to the FCC to explain.
Well, that's really good practical and political advice. So thank you. And so we're out of time. We have a lot more questions that we weren't able to get to, but I'll make sure that that Jerry and John get them so that they're able to respond to folks if they're able to. And I want to take a moment to thank both Gerry Lederer and John Gasparini for taking the time today to learn us about small cells and the appeals that are pending. Thanks a lot, guys.
Happy Easter. Happy Easter and good Passover to everyone. Bye now.
Thank you. Bye-bye.